Good morning, good afternoon, or good evening, depending on wherever you are. On behalf of the Department of Law, North Southern University, it is my privilege and utmost pleasure to invite you to this webinar. I have had the pleasure of going through Professor Meyer's wonderful draft. I'm reasonably sure that it's going to be published in one of the world's best law journals for sure. His insight, the way he has perceived the revolution in international economic law, that how the focus is gradually shifting towards regulating consumption, at least as an international law student, I could not foresee it the way he has foreseen. And his insight is not only original, it is very, very comprehensive. Through the lens of history, through the lens of case laws, both in recent time and also of mid-20th century, he has shown that how the focus on regulation, particularly in international tax law, in competition law, and in WTO law or international trade law, has shifted from territory to consumption. What may explain this change is perhaps there can be many ways of looking at that, but according to Professor Meyer, as I understand it, it is partially driven by the economic realities, the shift in some of the world's most advanced economies like the US, EU, Japan, and other parts of the world from predominantly a production economy to a consumption economy. And also, I guess, technology has had its part in the shift. Even today's webinar, in a way, it is delivered by Professor Meyer from the US. And most of us are sitting here in Dhaka. So if this were to be taken as a service, which we cannot call it as such because Professor Meyer is entirely doing it voluntarily for no reward whatsoever other than some academic pleasure of engagement. Where is it delivered from? It's delivered from the US, but it is being consumed maybe here in Dhaka and also some other people in some other parts watching it. So if we talk about Google, if we talk about Amazon, of which many of us are consumer, or Facebook, most of us are users of it, there is a revolution. So the thesis that Professor Meyer has, I think, is very innovative, it's very riveting, and I'm sure this session is going to be a fascinating one. I once again would like to thank Professor Meyer for his time and for kindly agreeing to deliver his talk for us. And I, of course, look forward to the questions from audience. Professor Meyer, the floor is yours.
Great. Well, thank you. Thank you so much, Professor. And it is a real pleasure to be here with you all virtually. I hope to, at some point, have an opportunity to travel to Dhaka and maybe meet some of you all in person or in the United States if you all are ever here. But it's great to be here. One of the really, you mentioned Facebook and Amazon and Google, but we should also probably acknowledge Zoom, which has made it possible for us to have these kinds of gatherings in a way that really, I think even 3 or 4 years ago would not have been possible, or at least we wouldn't have thought to necessarily do it. So I'm going to spend about 30 or 35 minutes just talking a little bit about the arguments in the paper. And then I'll look forward to your questions. This paper is very much a draft still. So I'm in the final stages of making sort of what I hope will be the last major revision to it. So your questions and comments, I'm very much looking forward to, and they will inform what I hope will be the last round of revisions to the paper. The basic thesis of the paper is this, and so I'll lay out the thesis and then I'll unpack it a little bit. The basic thesis of the paper is that throughout most of the 20th century, the sort of operating principle on which nations allocated the jurisdiction to tax and regulate productive activities was on the basis of where that production occurred. So the general rule, I refer to this as production jurisdiction, and the general rule was that the nation that had the productive activities occurring within its territory was the nation that had primary jurisdiction to tax and regulate that productive activity, and tax and regulate on the basis of that productive activity. And what we have seen across a range of international economic law areas is we have seen a shift towards what I call consumption jurisdiction, where nations increasingly take a territorial nexus with consumption, that is, the product, the service is being consumed within your territory, as a basis to tax and regulate on the productive activities. Okay, and so under the production paradigm, the production jurisdiction paradigm, only one country had jurisdiction or at least primary jurisdiction to tax and regulate productive activities. This is most clear. I'm going to unpack this across a couple of different areas, but this is most clear in the case of trade law, where throughout most of the 20th century, it was understood that it was not an acceptable practice under the to prohibit imports on the basis of how the good was produced in another country. Okay, the ability to regulate the production process was limited to the country in which the production occurred. And that is no longer the case. It is increasingly true across trade law. I'm going to talk about three areas of law. I'm going to talk about international trade law, international tax, and international competition law, what we in the United States call antitrust. Across all three of those areas, countries are increasingly moving towards asserting their ability to limit market access or to tax on the basis of productive activities that have occurred overseas. Okay, and that's what I call consumption jurisdiction. So I'm going to talk a little bit about that shift. I'm going to situate that within the general way we think about international law, and particularly jurisdiction, prescriptive jurisdiction within international law. I'm going to talk a little bit about that shift across those three areas. I'm going to talk a little bit about some evidence for why this is happening, why we see this shift. And then I'll talk a little bit about some of the implications of that shift. So that's going to be the structure of the talk. So first of all, if you've had a course in public international law or you practice public international law, you'll be familiar with the idea that international law does provide some limits on the ability of governments, of nations, to exercise jurisdiction. And in general, under public international law, we tend to think of jurisdiction as having sort of three different types. The type I'm primarily concerned with here is prescriptive jurisdiction. That's the jurisdiction to lay down, we often call it legislative jurisdiction. This is the power to lay down rules that have to be conformed to. And I'm primarily interested in this in the context of economic activity. And so if you think about the history of the way we tend to think about prescriptive jurisdiction, the primary basis for prescriptive jurisdiction in international law is territorial. And the idea has always been that a nation has essentially plenary authority, that is, it has almost absolute authority to regulate things that go on within its own territory. And other nations, by and large, don't have the ability to or the power to regulate or tax things that happen in a foreign country. Okay, so territorial jurisdiction in a lot of ways is the has historically been the primary basis for exercising what we might call legislative or prescriptive jurisdiction. But over time, there have been a whole host of what we might call extraterritorial bases for exercising jurisdiction that have evolved. So I'm not too concerned with most of them, so I'm not going to spend a lot of time talking about them. Nationality is probably the most prominent. A nation has the ability to prescribe laws that its own nationals have to follow, no matter where they are in the world. That is extraterritorial. That is, it would involve, for instance, the United States saying that a U.S. citizen must behave in a particular way, or a U.S. corporation must behave in a particular way, even when it's operating overseas. But the one I'm primarily concerned with, because it was developed and is really about economic activity, is the effects jurisdiction. And so over time, what we've seen is the emergence of effects jurisdiction as, at least within the economic space, perhaps the primary exception to the traditional territorial notion of jurisdiction. And so just at the outset, the kind of aim of this paper is to sort of convince everybody that although we've used these categories, and particularly the categories of territory and effects, that we really are observing is a different phenomenon. That the concept of territory is important, but it's not important in the way we have always thought. And the concept of effects is actually really an example of what I call consumption jurisdiction. And it's not the only example. And so when we focus on territory and when we focus on effects, we're actually missing the larger picture as in terms of what is actually driving the kinds of claims nations are making in the economic space to authority to tax and regulate, okay? And what I want to suggest is that the right question that we should be asking is not whether or not you have territorial jurisdiction or whether there is one of these extraterritorial bases, again, with effects being the primary one in the economic space. But what I want to suggest is that the right question is what counts, what kind of activity counts as a sufficient territorial nexus to trigger a country's ability to tax or regulate. Okay, what is the kind of activities that count as a sufficient basis for triggering a nation's ability to tax and regulate? And when we ask that question, what I want to suggest is that we're going to see that, again, across competition law, across international tax law, across international trade law, the traditional answer has been that a territorial nexus with production is the basis for jurisdiction. Whereas increasingly, we see that consuming a good, a product, a service, even potentially consuming capital in the form of investment, all of those have become increasingly seen as a sufficient basis for triggering a jurisdiction to tax or regulate. Okay, so that's the kind of big picture within public international law. I want to talk a little bit now about the three areas: so competition law, tax law, and international trade law. Let me start by saying that this trend that I'm describing, this shift from production jurisdiction to consumption jurisdiction, is not a trend that is occurring all at once across all of these areas. It's not a coordinated shift. It's not even really, I think, planned as such. Rather, within each of these areas of law, what I want to suggest is that the shift is being caused by a set of underlying factors that occur within each sector at different points in time. And so I'm absolutely going to, as I describe these three areas of the law, I'm going to be talking about different points in time within each of the areas of the law. Now, I'm going to start with competition law because I think competition law is really the area of the law where we first start to see this shift. And the reason is that competition law is the area of the law where this effects test is actually first developed. The notion of effects jurisdiction. That effects jurisdiction is just the idea that you have jurisdiction to regulate an activity that occurs overseas if it has effects within your own territory. Now, within competition law, the United States was, in many ways, the driver in terms of developing competition law. The U.S. Sherman Act it was a statute from 1890 that became the basis in the 20th century for really regulating market competition, for breaking up monopolies within the United States. And very early on, a case arose in the United States that involved fruit companies. It involved two U.S. fruit companies that were producing their fruit in Central America, and in particular in Panama and Costa Rica. And what happened, sort of without going into too much detail, is that one of these U.S. companies was accused of engaging in anti-competitive practices in Panama and Costa Rica. In particular, they were trying to squeeze out their competition, this other fruit company, and in particular, they were trying to corner the market in bananas. And so they colluded with the governments of Panama and Costa Rica to interfere with the ability of this other banana company to export bananas to the United States. And so the company that was the victim brought an antitrust case, a competition law case that went all the way up to the U.S. Supreme Court. And the question was whether or not the U.S. had essentially prescriptive jurisdiction to apply its antitrust laws, its competition laws, to this set of facts. And the Supreme Court announced what has become the sort of quintessential test for territorial jurisdiction. And the court said you cannot apply antitrust laws, U.S. antitrust laws, to this set of facts, because basically this set of facts does not concern productive activity that occurred in the United States. It occurred in Panama and Costa Rica, and therefore is beyond the reach of U.S. competition law, okay? Because territorially speaking, it is the governments of Panama and Costa Rica that are empowered to regulate the particular activities, in this case, the growing of fruit within those countries. Now, this case is regularly cited as the sort of basis in antitrust law and competition law for the territorial principle. But what I want to suggest is that it's pretty clear that what's going on here is not actually about territory per se, that it's about the territorial nexus with production. Because the United States had a significant territorial nexus with the facts of this case. The companies that were involved were U.S. companies. The scheme that had been alleged was planned, at least partially, in the United States. That's where the executives who put the plan in motion were located. And ultimately, the fruit was being exported into the United States, right? So the effects on consumers were going to be felt in the United States, right? So there was actually, I want to suggest, a significant territorial nexus to the United States. It just wasn't a nexus with the production activity, okay? And so what I want to suggest, first of all, is that in understanding these cases, these early cases, as being about territory only, we've misunderstood what was really going on. What was really going on was a nexus with production. If you've taken public international law, the Lotus case is sort of the equivalent statement often of territorial jurisdiction. And, you know, it didn't take long for the United States to shift to developing effects jurisdiction. And in particular, to start adopting the notion that if an anti-competitive scheme that occurred overseas had effects within U.S. markets, then U.S. antitrust laws could apply. And so this was in the 1940s. It was about 35 years later. The Second Circuit, in an opinion by one of the most famous U.S. judges ever, a judge named Learned Hand, adopted the effects test in a case called Alcoa. It involved aluminum processing, metals processing. And the claim was that a scheme that involves a restraint on competition within Europe had effects within the United States, and that was sufficient to trigger the basis for the application of U.S. antitrust law. And as I've already said, what I want to suggest is that effects jurisdiction of this kind is really just a species of consumption jurisdiction. Okay, the problem is that the end product, the metals in Alcoa, are being consumed in the United States, and thus the United States thinks it has the ability to apply its own antitrust law. So effects jurisdiction within antitrust law, I want to suggest, is the first example of consumption jurisdiction that starts to emerge. And across antitrust law, you see this jurisdiction spread. And so in the interest of time, I won't walk through this in a huge amount of detail. But essentially, competition law spreads, particularly after this end of the Second World War. It is particularly significant in Europe, which adopts a competition law policy eventually at the level of the Union, at the level of the European Union. Originally, of course, among its member states, and then through a series of decisions, adopts what is basically kind of like an effects-like test. So they never articulate the test in exactly the same way that the U.S. Supreme Court has articulated. But it's now the case that the world's major competition law authorities all basically agree that you can regulate, for instance, a merger among two corporations that occurs in a completely different country, if that merger is likely to have effects on consumer prices within your own territory. Okay. So that's competition law. And in a lot of ways, competition law is kind of the classic case for this. Competition law is not an area where there's a lot of treaties that regulate how countries cooperate. And so when academics, lawyers go to think about what customary international law requires in the case of prescriptive jurisdiction, they look to competition law a lot because there's a lot of state practice that is not really treaty-based. There's a lot of court decisions, there's a lot of sources, but there's not a lot of treaties. Tax and trade are different. So tax and trade are both systems that are heavily treaty dominated. Okay, and so one of the more minor points I want to make here is just that these tax and trade tend to be overlooked by public international law scholars who think about jurisdiction. And the reason they tend to be overlooked is because you have all these treaties, and also because the concept of jurisdiction is described in terms that are specific to those legal regimes. So they're not, that we don't use the term territory, we don't use the term effects, we use completely different nomenclature, but to describe it basically the same concept. So I just want to talk a little bit about tax and trade. And I'll actually talk about trade first, because trade is, I think, sequentially the next one in line. So as I already suggested in the introduction, trade law primarily is governed from 1947 by the GATT, the General Agreement on Tariffs and Trade. Eventually, of course, the GATT becomes the World Trade Organization in 1995. It's an institution that is approaching universal membership. It's got over 160 members, and it provides basically the rules, these sort of almost what I would describe as small c constitutional rules for the trading system. And throughout the sort of post-war period, that is the middle of the 20th century, it was understood that the trade regime limited the ability of countries to tax or regulate based on characteristics of production if that production occurred overseas. Okay. Another way to say this, because in trade what we're concerned about is essentially barriers to imports, primarily barriers to imports. Another way to say this is that within the trading system, what we were concerned with was whether or not a country could limit market access based on characteristics of production that occurred overseas. Probably the most famous case that sort of stands for the proposition that you could not do this in the trade space is a case, its official name is United States tuna. It's more commonly known as tuna dolphin. Basically, again, I'll just describe it very briefly. What goes on in that case is that the United States adopts domestically regulations that are designed to ensure that dolphins are not harmed when tuna is caught at sea. And it applies to US fishing fleets. And so the US wants to apply that same rule to imports of tuna from other countries, and in particular from Mexico. And so the United States does. The United States says, look, if you don't have dolphin-safe tuna, that tuna cannot be imported into the United States. And a GATT panel rules that the United States cannot do that. The GATT panel says this is basically an impermissible regulation of production, okay? Because the territorial nexus with production is in Mexico. It is not within the United States. The United States is free to do whatever it wants with respect to production of tuna by US fishing fleets in US waters, but it is not able to limit access to US markets based on the conduct of Mexican fishing fleets in Mexican or in international waters, okay? That's the original tuna dolphin. The United States is not happy with this, this rule. I talk a little bit about this in the paper. There's also an earlier example from the 1970s that involves a dispute with the European Union over taxing corporations. The basic concept here within trade law is known as border adjustability. Okay, and I'm not going to, just in the interest of time, I'm happy to take questions about it, but I'm not going to spend a long time describing it. But the basic idea here is that you do not have jurisdiction under this concept known as border adjustability. You do not have the jurisdiction to regulate or tax productive activities that occurred overseas. You cannot, in the trade context, limit market access, okay? And tuna dolphin stands for that proposition. When the World Trade Organization comes into existence in 1995, this almost immediately begins to change. There is a rerun, what is essentially the same facts as tuna dolphin in a case known as United States shrimp officially, or shrimp turtle. It's essentially the same facts. So except instead of dolphins that the United States is trying to protect, it's sea turtles, and instead of tuna that's being caught, it's shrimp. But it's the same basic set of facts. The United States imposes regulations limiting market access to shrimp that is not caught in a way that protects sea turtles. And ultimately, the WTO's appellate body upholds the US regulation. There's a series of proceedings about this, and initially the WTO says no, the U.S. is not behaving well, but ultimately the U.S. kind of tweaks its program, and the WTO's appellate body upholds what the United States did, this limitation on market access. And then there's a series of cases over the last 25 plus years, 27 years, that have kind of extended that principle. Again, I just in the interest of time, I won't kind of get into the weeds of trade law, although I'm happy to take questions about it. But the basic idea is the European Union is going to be allowed to regulate the import of steel products, for instance. It is going to have jurisdiction to sort of say, look, you cannot, even though we're essentially regulating the way a product is produced, whether or not it contains seal components of seals, you're not going to be able to import it, and that's going to be okay. Similarly, there's a number of cases that involve health related matters, asbestos, all of these kinds of cases where countries impose either taxes or oftentimes just flat out bans on the import of a product based on how it's produced. What I want to suggest here, and this may resonate with some of you, is that we're seeing a huge expansion of this in the trade space particularly as regards environmental measures. And so the big shift here is carbon border adjustments. So the European Union is imposing carbon border adjustments, where it is going to essentially charge what is essentially a tariff, a duty on imports based on the amount of carbon that is emitted in their home country, right? So if you produce a widget in Bangladesh and you want to import it into the European Union is going to charge you an additional tariff based on activity that occurred in Bangladesh. Okay, and so this is definitely the sort of primary example, I would say, of the shift to consumption jurisdiction. Okay, where the European Union, and I think it will not be long before the United States, Canada, Japan follow suit, think that they have the ability to essentially regulate what enters their markets based on productive activities that occurred overseas. The European Union has also done this with respect to deforestation. So this is the other main area where the European Union has said it's not going to, it's had a series of measures, but the most aggressive one has said, look, we're just not going to let in products that are from land in foreign countries that were deforested after a certain point in time. So if you cut down your forests to grow palm or to grow soy, the European Union is saying, look, if you did it after a certain date, you just can't come in at all, which is effectively a regulation on market access based, again, on productive activities that are occurring in places like Malaysia, Indonesia, Brazil. It's a serious bone of contention at the World Trade Organization as to whether or not the European Union can do that. Just quickly to round out tax. So the tax system is, again, actually a different system. So if the trading system is a multilateral treaty, the GATT, and ultimately the WTO, the tax system is one that is governed by a series of mostly bilateral treaties. And again, the legal concepts are nominally different. So we talk about in tax, we talk about source countries and countries of residence. But basically, when you get under this, it's the same distinction. It's about where the good or service is produced versus where it's consumed. And again, kind of glossing over some detail here, the same basic distinction holds, which is that in the 20th century, these tax treaties are applied in a way that says, look, if you produce a good in a particular country, you cannot, a country that imports that good or imports that service cannot tax the production of it. You can, of course, tax the consumption, you can have sales taxes, you can have a VAT, but you cannot tax the activities that occurred in the country of origin. And the major pressure, and we already sort of heard a little bit about this in the introduction, the major pressure on this system has been the emergence of digital services. Okay, there's actually been two. One is digital services, and the other is pharmaceuticals, where you have countries, you have companies that have become sufficiently sophisticated in incorporating within countries that have low tax rates that they're essentially able to avoid taxation entirely, because they will provide a service from a country in which they pay very low taxes. So oftentimes this countries like Ireland, they pay very low taxes, and they don't need to have a physical presence in other countries. So there's no territorial nexus that, for instance, France necessarily has with a company like Google. Google can provide all of the internet services it wants to provide to France from California in the United States. And so what we have seen, and again, I'm going to sketch this out very briefly in the interest of time, is just that you had these countries start to impose what are called digital services taxes, and a whole range of countries did this, where they were going to start taxing a portion of the revenue from these companies based on whether or not these digital services, using Facebook, using Google, potentially using Amazon, whether or not the consumption of those services was occurring within, for instance, France. The United States got very upset about this. The United States threatened to impose all kinds of trade sanctions on, particularly on France, but on other countries as well. And ultimately, this was resolved via what's called a two-pillar solution. It was an OECD negotiation that has resulted in an agreement that is going to allow countries essentially it's going to allow countries like France to get what they wanted. There's going to be a formula that is going to allow them to tax the revenue of these very large digital service providers on the basis of a percentage of how much of that company's revenue is generated from consumption within their own borders. Okay, and so again, we see this very clearly, a shift from production to consumption. The old rule in the digital services area, the old rule even 10 years ago was if the service was being produced, for instance, in the United States, where a lot of these major digital service providers are located, the United States could tax them. But the consumption of those digital services could not be taxed because there was no territorial nexus that a country like France, for instance, had with those companies. And now the rule going forward is going to be that those countries do have the ability to tax Google, to tax Facebook, based on the amount of consumption of those services that occurs in those countries. So that's the shift, okay? The primary aim of the paper is really to convince you that this shift is occurring and that this is really what jurisdiction is about. And it looks like I'm doing okay on time, but tell me if I'm not. Just in I think maybe the 5-ish minutes left, I'll just tell you a little bit about why this is happening and what the implications are. So first of all, why is this happening? So what I want to suggest is that in the international system, it is, for better or worse, the case that rules are often established by the countries in the economic space that are the major economies, the major importers and exporters. These rules are not established, again, for better or for worse, they're not established by voting at the UN General Assembly. They're not established actually even by voting at the World Trade Organization in the trade space. They tend to be established through diplomatic engagement that's often driven by the economic interests of very large countries. And so in the 20th century, those countries, the European nations, the United States, Japan after the war, they are very interested. Their primary policy goal is economic growth. They have a mandate, particularly after World War II, to rebuild the economies of the world that were essentially devastated by that conflict. There is a sense that, certainly this is true in the United States, that there was a middle class that was emerging that needed to be supported, and that economic growth was the way to do that. And production jurisdiction, I want to suggest, supports economic growth by limiting taxes and regulation. It limits taxes and regulations because it basically says only one country can tax and regulate production. There's not multiple taxes, there's not multiple sets of regulations you have to comply with production. Under production jurisdiction, if I'm Google and I'm located in the United States, I only have to pay, for instance, the US tax rate. I don't have to worry about paying taxes in France and Germany and Brazil and India. If I produce a product, if I produce, for instance, if I'm a Mexican, the owner of a Mexican fishing vessel, right, I can catch my tuna and I can export it anywhere in the world without having to worry about what the specific regulations are that apply to the production of tuna in those countries. Okay, it's just a much simpler economic system that really facilitates the growth of international trade and investment. And so it made sense when economic growth was the primary goal to have production jurisdiction in place. And what's happened over time, though, is that these countries, the United States, what ultimately becomes the European Union, and then other nations, I think following those tend to be the sort of two largest economies for much of this period through the 20th into the 21st century. They become consuming nations. And I think this will be a familiar story. Increasingly, the production, first of goods, is outsourced to a range of countries, but often in Asia. And then increasingly, services are now outsourced as well. So increasingly, even digital services in the tax context are often being moved because these companies will be housing some of their suppliers, some of their centers will be housed in countries, again, often in Asia, for tax reasons, sometimes in places like Ireland. And so you see this major shift in which these sort of the world's leading economic powers are becoming net consumers of first goods and then services. And what I want to suggest is that that is the tipping point in any particular area of law from production jurisdiction to consumption jurisdiction. And the reason has to do with domestic politics. When you start becoming a net consumer of goods, or services, all of a sudden you have a natural alliance between domestic producers and people who have a range of interests in other kinds of policy goals, who will start to band together to say, look, we need to have more stringent restrictions on access to our markets that include taking into account how much carbon was emitted overseas, or how much was child labor, for instance, used in the production of these goods. Okay, and so I'll just give you a brief example of this that draws on the carbon border adjustment system that the European Union is implementing. So, in the 20th century, when the European Union, and you think of Germany, think of England, right? These are industrial centers that are emitting a huge amount of carbon, right? I mean, we know that climate change is primarily caused by the United States and Europe. Those have historically been the major emitters of carbon, and they were happy to do it. Because what they were doing was they were generating a great amount of economic production that could be consumed domestically, but was also being exported to other countries. And so all of these companies, right? Think about auto manufacturers, right? General Motors in the United States or Volkswagen in Europe. If you think about major industrial companies, chemicals producers, metals producers, they have no interest in any sort of set of regulations that they might face in countries that are importing their goods. They want to keep those regulations and taxes as low as possible. And so they do that by pushing this notion of production jurisdiction, right? Within the trade context, they're going to say, look, you cannot impose regulations, you cannot limit market access based on how we produce this at home, how much carbon we emitted in Germany. And they're going to say, look, you cannot tax us twice, right? These are the bilateral tax treaties. Look, we can only be taxed in our home country for the production of these products, right? That's where we're located. We're in, for instance, Germany. Today, that's no longer the case. And so the European Union is going to impose this carbon border adjustment mechanism that's going to say, look, we're going to tax carbon at home, to be sure. So that German producer is going to get taxed on the amount of carbon it emits, but so is every other producer anywhere in the world that tries to access the European market. And the reason that works is that the position of German producers is the same, right? There's no change in the position of these German producers. They still don't want to pay those taxes. But the amount of consumption within, for instance, Germany is increasingly goods that are not produced in Germany, right? German producers increasingly are not producing for the German market. And instead, what you're seeing is production that is occurring elsewhere that's being imported into, for instance, Germany. And so those German producers that do produce for the German market want to make sure that they are not facing competition from cheaper imports. Okay, and so part of the shift to consumption jurisdiction is basically protectionism. It's about raising barriers in order to protect what remains of domestic production in these old economies that are shifting from being producers to consumers. At the same time, though, that protectionist instinct is essentially melded to a whole range of other policy goals that these countries have. Okay, and the European Union is, again, I think, the most explicit about this in saying, look, we, the European Union, have an interest in ensuring that our consumption of a product does not cause something that's bad in the world. Okay, it doesn't cause deforestation. It doesn't cause climate change. And so the European Union has been very explicit in saying that, look, we've got groups within Europe that want to make sure that we are not causing deforestation by our essentially consumption practices. And so you get the melding of those two very different sets of policy goals. Okay, one set of policy goals is purely economic, and it's just essentially traditional protectionist type interests in ensuring that the cheaper imports from countries that have lower regulations, lower taxes, don't sort of put out of business domestic production. But you also have a political interest in these countries in ensuring that consumption within their own markets is not supporting particular things in the world that those countries don't themselves want to see. Things like climate change, things like child labor. Those have been particularly the big ones. The United States has been particularly aggressive within the revised North American Free Trade Agreement. The USMCA has been particularly aggressive about this with respect to labor practices, and in particular the right to unionize. So you're seeing much more of this idea that we can condition market access, we can impose taxes on the basis of these kinds of activities, partially to ensure that we retain some domestic productive capacity, but partially to advance a whole range of other policy goals that just weren't present in the 20th century. Right? In the 20th century, particularly the middle of the 20th century, we weren't worried about climate change. We weren't worried so much about labor practices. But the sort of rise of those goals in prominence, particularly within places like the United States and the European Union, has totally shifted the political calculus. And I want to suggest the reason that they're able to do that is because the burden of those kinds of regulations and these new taxes are primarily felt overseas, right? The Europeans who elect members of the European Parliament, who elect their own national governments, they don't have to pay the taxes of the Indian company that produces goods and then has to pay a carbon border adjustment when those goods are shipped in to Europe. Europe deforested many years ago. And so there's no deforestation regulations that are going to meaningfully affect European production, but it's sure going to affect production in places like Malaysia and Indonesia. And so you see those things. You see those things working together. I'll just say something very briefly, and I'm happy to take questions about implications, but I'll just quickly highlight a couple and then look forward to your questions. So the first implication is just that there are going to be major distributional implications to this shift. This is going to be something that is basically probably a good thing for producers that are located in places like the United States and Europe. This is not going to be great for producers that are located in the developing world. And so, there's really a trade-off here between the ability of major economic powers to pursue these larger set of goals through the economic system and our efforts to promote development throughout the world. The second implication is that this promotes a race to the top. So throughout the 20th century, we often worried that there'd be a race to the bottom that would occur through liberalizing trade and reducing taxes. I think one of the things we see here is that there's really a race to the top because producers are going to be subject to multiple different kinds tax systems and regulatory systems, which is going to encourage them to actually probably comply with the higher standards in order to ensure market access. And the third implication is just that we see this very clearly, and I won't dwell on this, but these shifts have been accomplished relatively smoothly in places where there is not multilateral governance. And the place where there is multilateral governance, which is the World Trade Organization, has been the institution that has had the hardest time coping with this change, to the point that the dispute settlement system at the World Trade Organization no longer functions as a practical matter. It may get restarted. There's a lot of effort to rebuild it, but the WTO has had a much harder time coping with this shift than has the competition law system and the tax system. And I want to suggest the reason for that is that more mature systems of government just have a more difficult time with fundamental changes to the assumptions about how law works. So I'll stop there. I think I probably talked a little bit too long, but I'm happy to take questions. And again, happy to stay a little bit late as well.
Thank you, Professor Meyer, for your excellent talk. We have quite a few questions. The first question that I would like to put to you is, in a way, is this focus on the literature, on territory as a basis of jurisdiction, was it somehow misplaced? Because I guess you were showing that even in some of the classic cases, it was not just on territory, it was something more. Thank you.
So I think that's right. I think that the notion of territory in those early cases is sort of obscuring the fact that it's not just territory. So, and I think the current draft I think doesn't do it. One of the revisions I'm making is to be more clear about this. Territory is important. And so territory absolutely is a critical factor, but the question is territorial nexus with what? And what those early cases miss is that they seem to say territory is enough. And the absence of territory, barring one of these exceptions, the absence of territory means there's no jurisdiction to regulate. Whereas I think what's really going on in those cases is it's territory plus. And territory plus what? In the early cases, it's territory plus production. Okay, and again, I think you see this most clearly in the competition law cases where there's a major territorial nexus that in these cases the United States in particular has. It's just that the thing that is missing is a territorial nexus with production. Okay, and so you kind of looking back, I don't mean it as a criticism of the of these early courts. I think they were thinking of these in the terms that they had at the time. But I think looking back, it's clear that it was territory plus production that created jurisdiction, not just territory.
Thank you. The second question asks that some of these changes would perhaps need some sort of global industrial policy, and we are far from that. So what does the future lie?
Yeah, so that's a great question because we are seeing a shift in a number of countries towards industrial policy, and obviously, actually, we've seen industrial policy. And again, actually, Asia has been a really effective practitioner of industrial policy for many years. When you've got China, obviously, but also India, Taiwan, South Korea, that have all effectively leveraged industrial policy as part of a development strategy. And one of the things you're seeing is that this is spreading to, in particular, the United States and the European Union, which have been historically a little bit more, these terms are bandied about, and so I'm a little, it's always a little hard to know what they mean, but I'm going to put air quotes and say, they've historically been more market-oriented, and they're now clearly embracing industrial policy. And so I think, you or the questioner is absolutely correct that one of the things that could really ease the transition to consumer jurisdiction would be some sort of multilateral agreement on acceptable industrial policy practices. So let me just say two things about that. So first of all, in the absence of such an agreement, I think what we're going to see is what we're already seeing, which is a lot of unilateral action. You know, the European Union is imposing its carbon border adjustment measures, its deforestation measures, without asking anyone's permission, and frankly, without really trying to negotiate with anybody. They announce their plans, and only after they announce them do sort of negotiations begin. That same thing is true in the tax context. The absence of negotiations or of successful negotiations caused a whole range of countries to unilaterally impose these digital services taxes. And it was only the imposition of those digital services taxes unilaterally that then really spurred this OECD multilateral negotiation. So I think, first of all, we're likely to see unilateral action in the absence of the agreement. Second, though, I think like the OECD agreement on what's called the two-pillar solution on digitalization, I think that these unilateral actions actually are creative in the sense that they spur negotiation, because nobody really wants these kinds of conflicts to linger for any length of time. And so I think you're going to see negotiations that are hopefully going to produce multilateral consensus about how to apply these norms. But I think it's going to be the hardest in the trade space. And the reason is that there's already a multilateral institution in that space that has rules that are difficult to sort of adjust to this framework. And frankly, the easiest place within the WTO space to adjust these rules would have been to do it by interpretation at the appellate body, and there is no appellate body anymore. So, you know, I think the absence of negotiations, functioning negotiation at the WTO, really does mean that getting to a consensus on industrial policy for trade and goods is likely to require considerably more effort than it will in the tax and competition law space.
Thank you for that answer. The next question says that a more complicated tax regime would probably favor larger companies. Can the competition law help in leveling the field for the smaller players?
So I think that's right, and I think competition law. You know, there's been a real, I think, renewed interest in competition law. Actually, again, driven to a large extent by these huge digital service providers. And so, you know, one of the things you see in places like France, places like India, that are imposing, that initially, you know, sought to impose these digital services taxes, is you also have seen an increase, particularly in Europe, in interest in imposing competition law limitations on the size of these large digital service providers, as a way to encourage and spur development of local digital service providers. And so India, in some ways, has been the most explicit about this in the digital services context, although it's pretty clear in some of the records within the European countries. Again, I've looked particularly at France. So I think that's absolutely right, that one of the underlying concerns, and actually I should probably say more about this in the paper, one of the major underlying concerns, policy concerns, that is much more present now than it was in the 20th century is competition. That, you know, particularly the United States by the 1980s had really gotten away from enforcing our antitrust laws in a vigorous way. And the resurgence of an interest in breaking up monopolies, I think is one of these major policy goals that is animating not just competition law, but also the tax, and to a lesser extent, maybe the trade the areas.
Thank you. The next question asks, would the proposed EU deforestation law breach the WTO law? And secondly, where is the starting point of that deforestation? Is that in some ways protectionist?
Sure. So let me take the second question first, because it's relevant to the answer to the first question. So the way the EU's proposed deforestation measure is going to work is that it's going to pick a date. And I think, as I recall, that date is 2020. And it's going to say that any products produced from land that is deforested after 2020 are subject to the EU's deforestation rule. So let me just take two countries. I'll take the United States as one example, and I'll take Brazil as another example. So the United States used to be covered in forests. We chopped down most of our forests during the 19th century. And so if you go and you look at a map of the United States, you can actually see, you can find these online, where there's just huge deforestation that occurs in the United States, but it occurs during our Industrial Revolution, which was really in the 19th century, a little bit in the early 20th century. By the mid 20th century, most deforestation in the United, and this is true of Europe as well, most deforestation has already occurred. This is not true in somewhere like Brazil, which continues to have a huge amount of forest, rainforest in particular, because Brazil didn't industrialize to the same degree in the 19th century. And so Brazil, a country like Brazil, a country like Peru, a country like Indonesia or Malaysia, who are also involved in this, disputing this with the European Union, they look at this and they say, you've picked a nominally neutral cutoff. You said 2020. You're not singling out Malaysia and Indonesia and Brazil and Peru, but in fact you are. In fact, you're favoring the countries that are already industrialized, because those countries will have already deforested. And so you've picked this ostensibly neutral criterion, 2020, but in fact, it's not neutral at all. It is designed specifically to protect industrialized major economies that industrialized early in the sort of economic development cycle, to the harm, to the detriment of those countries that are still trying to industrialize and engage in economic development. So that's the reason it's protectionist, and that's the argument that it violates. It's also the argument that it violates WTO rules. I don't think there's much question that it does violate the WTO's non-discrimination rules. So as they are currently understood. So the WTO has basically two kinds of non-discrimination rules, most favored nation and national treatment. Probably this violates both of them because it benefits, for instance, the United States as opposed to Brazil. It also benefits European producers as opposed to Brazilian producers. So it probably violates both most favored and national treatment. The question is going to be whether or not a WTO panel would excuse the European Union's violation under one of the exceptions to the GATT rules, and this would be Article 20. Probably Article 20G, about whether or not this is a measure that is related to the protection of exhaustible natural resources. I don't know. I would hesitate to predict an answer to that question. I think and this is actually in many ways what the paper is about. 20 years ago, the answer to that question would have been that the European Union would have lost, because that exception would have been applied in a way that would have said, this is about production in Brazil, about production in Indonesia, Malaysia. It is not a matter that the European Union can just wade into. Today, though, I think those norms are shifting, and I think it's much more likely that the exception would be applied in a way that at least largely upholds what the European Union has done. They may sort of suggest revisions to the measure, but it would not be a surprise to me if ultimately this is upheld under Article 20 of the GATT.
Thank you. We are already out of time, but I would just ask one more question. You have mentioned that this focus on consumption is going to lead to a race to the top. So for whom is that? Is it for consumers, for producers, or for states?
Sure. So so the literature on kind of race to the bottom, race to the top is really focused on producers. And the question is whether or not producers are going to try to find the place where they can produce whatever it is they make at the lowest cost in terms of taxes and regulation, or are they going to try to produce to a higher level? And so it's primarily about the behavior of producers, although it obviously has implications for consumers and for states in terms of what kinds of goods are available on the market, right? Goods and services. You know, a lot of the concern has been that, you know, if you reduce barriers to trade, if you reduce taxes by allowing countries to sort of effectively pick which country they're taxed in, that companies, producers, will move to the lowest tax jurisdiction and the jurisdiction that has the least regulation. Okay, they'll go somewhere where you know, there are no environmental regulations about you know, not emitting carbon dioxide. There are no limits on you know, maximum hour or minimum wage rules, right? And therefore labor will be cheaper. That's sort of been the traditional concern about the 20th century economic system, and that's what we call a race to the bottom. The reason that I think consumption jurisdiction creates a race to the top is that, and this is less about the behavior of producers and more about their inability to escape the regulation that states impose. Because if the United States is free, or you know, any country is free to condition access to its markets based on productive activities that occur overseas, well, if you're trying to access the European market or the US market, it doesn't help you to go somewhere that has no, you know, for instance, no right to unionize and thus has lower labor costs. If when you try to re-import those goods into the United States says you can't bring those in because they were produced with non-union labor. Okay, and so this has been a major issue since the new NAFTA, the new North American Free Trade Agreement, came into effect. It's got new rules on, the reason I'm talking about unions is because that agreement has new rules on unions. And the United States has been very aggressive in saying, look, Mexico, you need to provide an effective right to unionize at specific plants. And if you don't, you know, there's going to be trade sanctions. And so for those factories, you know, those companies that move production to Mexico, it no longer allows them to escape essentially US labor law if they want to access US markets. And so consumption jurisdiction, I think, really shifts, it takes away the benefit producers were getting from their location decisions in a globalized economy.
Thank you for that answer, and of course for your excellent talk. Have a good day.
Yes, thank you as well, Betty.